Gobble gobble, everybody. Nothing says Thanksgiving like stuffing your face full of food. One giant meal and then one giant nap. Speaking of, can your client contract require a meal? Today on the Thanksgiving episode of the Wedding Industry Law Podcast. Stick around.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the show. I figured that what better episode to have for the week of Thanksgiving than one dedicated to the tradition of eating and taking naps. No, just kidding. Just eating. And that is to say, is it legal? Is it standard procedure? Is it normal in the industry to require that your client in the contract, require that your client provide you and or your crew with a meal? I feel like, I've done billions of contracts at this point. I've talked to billions of wedding industry professionals. And I feel like of the, I would say, quote unquote, non-essential contract terms, this is kind of like the most disputed. Like this is the one that draws out the most opinions. I've got people on one end of the spectrum that I've been told that's like the most tacky thing they've ever heard. Like literally, more than one. Like this is not some type of like one-off, one in a million. Multiple industry professionals that I've worked with before on contracts have said, Rob, I don't want that in my contract. It's tacky to ask for food. I work 12 hours, no food. I don't even need water. I take a Tic Tac. That's it. On the other end of the spectrum, you've got, I want fine dining, like they stuff the handkerchief or the napkin in their collar and they eat. Okay, so you've got all ends of the spectrum, but I guess it's just strange. You never hear somebody being like, it's tacky to have a limited liability clause. It's tacky to have a non-refundable deposit. It's nothing like that. Like these things don't draw out the opinions as food does. So I thought it would be fun to talk about this. So in short, can your contract require the client to provide you and your crew food? Yes. Typically, as I've said on this program many times, you can pretty much contract around anything that you want. Anything that you want. As long as it's not illegal. You can't hire somebody through a contract, kill somebody else. Can't do that. You can't contract for illegal criminal things. But if you're two consenting adults, and there's an exchange of consideration, you meet all the elements of a contract, you can do it. So by and large, it's done a lot. So as I said, like this is something that draws a lot of opinions, but by and large, most of my clients require a meal, have the client require a meal in the contract. So if you're one of those people, good for you. If you're thinking about adding that into your contract, here are some considerations for you. So now that we've established it, probably you can do it. More than likely you can do it. Most states, there's absolutely nothing wrong with doing it. What are some things to consider in order to do it right? In order to make sure that there is no issue that when you get to the place and they hand you a bag of baby carrots and they say, here you go, congratulations, chomp down on this. Or if you get there and they want you to eat, I don't know, a full rack of ribs. How am I gonna eat a full rack of ribs and also, coordinate the wedding or photograph if I'm going to go take a nap after I'm done eating it? Anyway, so here are some considerations. First of all, the first consideration is going to be what form that the meal takes. Now, you're in for rude awakening depending on how nice your client is. If it just says, I need to get a meal. Okay, so you have to tell the client what kind of meal. And this usually takes a few forms. The first form, as you probably already know, is typically if the event is catered in some way, if the event has food, a lot of times that provider in order to cut costs for the clients, will have vendor meals, meaning that the guests will eat the nice prime rib and the vendors are going to get a turkey sandwich. So it's the vendor meal. So you can say, I'm fine with the vendor meal. You can also, in terms of the type of meal, the form of the meal that it can take is a guest meal. So you can make the client require you to have what the actual guests are eating. So you can eat the prime rib. So vendor meal, guest meal. Then you can say, you know what? I don't care. You can get me Arby's, doesn't matter. So non-vendor, non-guest, whatever it takes. So the first consideration is just to make sure that if it's important to you, to get your nutrition, that you tell them that this is what I want. It's almost kind of like the writer. Like, I don't know if anybody out there was a band in the 70s, 80s, 90s called Van Halen. I don't know. I feel like I qualify as an old guy now, so I don't know if that's a reference that people don't understand. But anyway, the urban legend is that the writer or the contract that Van Halen would have when they would go to a concert, to an arena, would be that they would want a bowl on a coffee table filled with just green M&Ms, only the green M&Ms. And everybody's like, wow, like what divas? Like, why would they want a bowl of just green M&Ms? And the reason is because if they came to the backstage area and there's a bowl of green M&Ms, that they know that the promoter or the person they contracted with, the concert or the arena, read the contract writer. And so walking in and seeing the green M&Ms, they know that, okay, well, then all the other things that we requested are probably okay. So anyway, I digress. That was just an interesting story about, Van Halen requiring a certain meal, so to speak, as a way to indicate whether or not the person read their contract. Anyway, okay. All right. So make sure that you have form of the meal. All right. The next thing is, oftentimes you are just eating in the corner whenever you have a chance. Okay. So the next recommendation is to, if you so desire, to let the client know that there is a designated time, if any, that you're going to consume your meal. So oftentimes, vendors are eating for a few minutes when everybody else is eating, because that's usually when the action dies down, but maybe not for you. Maybe it's another time. So if it's important for you to be able to sit at least 15 minutes and consume something, if the day is long, then I would recommend that you say, typically, we consume our meal as the vendor at this certain time of the event. So letting the vendor or letting the client know when you want to eat is important, because that's going to minimize the risk of them coming at you later on because you missed an important shot or you weren't there when somebody came in or something like that. Well, this was, as we agreed, the designated time that I'm going to eat. Now, so type of meal, time to consume. Now, to a lesser extent, there's location of the meal. So sometimes I've seen clients will say, if you're not offering food or you don't agree to give me food, you're going to give me the ability to actually leave the event for 20 minutes, 25 minutes to go get something. That's a little bit rarer, but again, as long as you make clear the parameters of where you'll be and why that's the case, typically you're going to be okay. Like, you're going to be more or less, not necessarily off the hook, but there's less likelihood of an argument that if you miss something during that time period, that you'll be sued for it. So location of where you're going to eat sometimes is important. So not quite as much, but I just wanted to throw that out at you. The other main recommendation that I have is to make sure that you identify with the client who is getting the meals. So that might tell the client how many they have to prepare. So is it just you? How many people are you bringing with you? Are they eating? Sometimes your assistant doesn't want to eat. Sometimes they do. Whatever the case may be. So you want to make sure that your contract specifies, not just, XYZ professional, but XYZ professional and all personnel providing the services, or all, XYZ professionals on site, something along those lines, making sure the client is put on notice that it's not just one meal. You got to feed a bunch of people. So don't, it's not just four people are splitting a bag of Doritos and a turkey sandwich. Like, you got to make sure that, you specify how many you need. All right. Now, at the end of the day, how is this clause enforced? How is it enforced? Like, if you go there, you said, I want one guest meal for me and my one assistant. You get there, they hand you a bag of Doritos, Cool Ranch, and a turkey sandwich, and they say, here you go. And you look and like, well, you're serving prime rib. Why am I getting a turkey sandwich and Cool Ranch Doritos of all Doritos? It couldn't be taco flavored or nacho cheese or even Flamin' Jack. You gave me Cool Ranch. So what can you do at that point? Can you leave? Is that a material breach? Probably not. Probably not, unless you make it a material breach, which would be crazy. We've talked about the consequences of material breach in previous episodes, so I won't go too much into it. But mostly, folks, you're putting in this provision in your contract just to let the client know what you want. If it doesn't happen the way you want, it's almost always not going to be something that you can sue over. Think about it. So, hey, Your Honor, I'm suing them for $15.80 because that's, what the per guest cost was for the meal, and I didn't get the guest meal, right? How ridiculous that is. So, we put that in the contract, but typically the enforcement mechanism is extremely weak. You can be like, hey, where's my guest meal? In my contract, it says X, Y, and Z, and then you get it. That's pretty much what the action is going to be for you if they don't do it. Hey, listen, everybody's, you gave me this turkey sandwich and a bag of Doritos. Thank you so much. Even though it's Cool Ranch, I appreciate that. But we contracted for a guest meal. So could you make sure that we get a guest meal? That's probably what you're going to be looking at. So at the end of the day, our contract can be an important enforcement mechanism for our rights. So suing a client because they didn't pay us, or suing a client because of a material breach of an important clause, usually money, that's okay. In this instance, it's just a piece of paper to show the client, hey, listen, we're in the process of this wedding and you're doing me wrong. Can we make it right? And then they can either make it right or they can make it wrong. And if they continue to make it wrong, then what can we really do? We just have to go with the flow. We just got to go with the flow. But I would say this, let the client know if meals are really important to you. And it could be like there's some of us that have health conditions like, hey, I got to eat or my blood sugar is going to go down and, whatever. But I also, at the same time, I can't carry a bag with, Doritos and a turkey sandwich around with me that I bring like a elementary school kid, my little lunchbox. I can't hold that around. So it's important that I get a meal, and it's important that you provide it. You let the client know work potentially could suffer if you don't get the food. That's a possibility. That's why I think some people it's important, some people it's not quite as important. Hopefully you found this episode extremely important, extremely satisfying in the way of legal learning, the wedding industry. I will say this, if you're watching this or listening to it, congratulations. You are probably the only person watching or listening. The stats are in. This show is almost certainly not Game of Thrones or, I don't know, Mandalorian. What are people watching now? So feel proud. But at the same time, you as the only listener, as the only watcher, have great responsibility. And that responsibility is to please tell somebody about this program. If you're finding it interesting, share it. Put it in somebody's stocking. Put it in somebody's stocking coming up for the holidays. Just put it in there. The Wedding Industry Law Podcast. Boop, boop, boop. There you go. While you're at it, like and subscribe. Share it. Write a review. Do something. Let me know that you're out there. Just that one person. It's not my mom. Mom stopped listening a long time ago. So it's just you. It's up to you. Only you can prevent forest fires, but also at the same time promote the hell out of this show. Anyway, like and subscribe. If you got any suggestions for content, every once in a while I do get a suggestion for content. I got one the other day, which I will put into an upcoming episode. It will be a COVID-19 2021 recap episode where we're going to talk about all the things new to the COVID legal world for 2021 and where we're headed. So with that, new episodes every Monday morning. Check us out, YouTube, Wedding Industry Law, or wherever you get your podcasts from. And with that, folks, happy Thanksgiving. Be safe. Wear masks. Wear face shields. Wash your hands. What else? Socially distance. Okay? And don't fight. No fighting. As much as you can. Well, okay. You can fight. Just make sure it's socially distanced. Anyway, with that, folks, we'll see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.